The next area of liability in law enforcement activities that we need to address is the all-important federal claims against law enforcement agencies. This is probably one of the more important discussions, I would say, in the top two or three issues that law enforcement agencies and agency managers need to be cognizant in this area because it can have detrimental impact, almost fatal impact to a law enforcement agency if it is a big case, a high publicity type action. So we're going to get into that, but let's jump full force into federal law. Our discussion is going to be all about federal law. Our previous seminar online was state torts and state statutes and state laws and those types of liabilities law enforcement agencies are exposed to under state claims. But this particular discussion is about federal law, the liabilities that an agency is exposed to under federal laws, and addressing full force the main area or the main law in this area is Title 42 USC 1983, more popularly known as 1983 actions. These are very, very serious. I can't emphasize how serious these are, and you'll see why shortly. But let's first start with the history of the 1983 actions. It really stems from the Civil Rights Act of 1871. Post-Civil War era, where discrimination and outright hatred of minorities, specifically African Americans, still existed, and it was prevalent throughout the South and ingrained in the governmental systems, both state and local systems, and ingrained inside the local police departments and the county sheriff's departments and even the state agencies. So to help root out and clean up the remaining state and municipal discrimination against minorities by police departments, the legislature in Washington, D.C. passed the Civil Rights Act of 1871. It was known as the Ku Klux Klan law, to purify the workforce, the law enforcement workforce, and root out the Ku Klux Klan, which was very powerful and ingrained in some instances and working hand in glove with the local governments. So this was a remedy, a right to sue law enforcement agencies and really inflict heavy monetary damages and consent judgments. And we'll talk about all of that. Most civil lawsuits against police officers are filed under the now known 42 USC 1983 section. So it has evolved into the modern, as we know it, the modern law 1983 actions. And it serves the purpose of prohibiting or depriving another person of a federal or constitutional protected right. So in other words, these particular lawsuits address violations of law by law enforcement personnel of federal laws or the U.S. constitutional protected rights. Life, liberty, property can all be taken by the government, but cannot be taken without due process. So all of these 1983 actions, they stem from an allegation that law enforcement personnel have violated a federal right or a federal law or a U.S. constitutional right or law. It doesn't deal with state laws. One of the first noted cases under the 1983 action and section was the Monroe versus Pappy case in 1961. It dealt with Chicago Police Department case of brutality. The Chicago Police Department suspected Monroe of a murder. In the early morning, 13 police, led by Detective Pappy, burst into Monroe's home and entered his bedroom. They woke up Monroe and his wife from sleep and pointed guns at them and had them stand naked in the living room. They manhandled Monroe's children and beat Monroe and called him racial epithets and cursed at him, etc. They ransacked the house and took Monroe to the station and interrogated him for 10 hours. He was denied a lawyer and no charges were ever brought against him. Pappy had no search warrant or an arrest warrant. Ultimately, as you might expect, Monroe sued under this particular action and claimed that the local law enforcement officers as well as the agency was liable. And they were. The courts found, obviously, in favor of Monroe. Now, one of the core elements of a 1983 action is that, first, it must be a law enforcement agency acting under color of law. What that means is they're acting in their official capacity. It's not off-duty, even though some off-duty conduct qualifies for 1983 actions, such as working details or exerting police force while off-duty. Police powers, I should say, while off-duty. In 1983, Supreme Court held that 1983 actions could be used to redress constitutional deprivations that were not sanctioned by law or custom, i.e. rogue police. Congress meant to provide a remedy to parties wronged by an official's abuse of position or power. So this all came from the famous Monroe versus Pappy Supreme Court case in 1961. Another case to follow in 1978 was the Monell decision. The United States Supreme Court held that some government entities were persons and thus could be sued under Title 42 U.S.C. 1983. So municipal and local units are considered persons susceptible to 1983 actions. There was a whole host of litigation of whether you could just sue the agency or could you just sue the law enforcement officer, the rogue officer, or the rogue deputy themselves. Ultimately, the Supreme Court cleared it up by saying that not only can you sue the individual deputies or officers for misconduct under 1983 actions, but also their employers, municipal and local government employers. It's a way to bring change to policy and conduct, if you will, by suing agencies that gets police departments' attentions, especially if they have to pay out a lot of money. So it's a way of social control of police power. And especially if the result is of poor training or supervision of the rogue officer, then the Monell decision allows for these lawsuits to proceed against the employer, i.e. the law enforcement agency themselves. Now, you're going to hear a lot about, in your readings in this area of law, the deliberate indifference standard. Deliberate indifference. Police officers and municipal governments can be held liable under the provisions of Section 1983 if the police conduct results in the violation of citizens' constitutional rights due to the deliberate indifference of the police officer or the municipality. That is a legal standard now, articulated by the federal courts and adopted throughout the United States. If the actor, the rogue officer, or their employer, i.e. the law enforcement agency, acts with deliberate indifference, meaning purposeful non-caring of the situation, they are liable. A violation occurs when a deputy or law enforcement officer is acting under color of law and violates a person's civil rights, i.e., one of those federal rights or U.S. constitutional rights. It does not create any additional rights. It is just a mechanism. This 1983 action is a mechanism to enforce and protect civilian rights, and also to collect for damages that have been caused by the rogue officer. There is concurrent jurisdiction in state and federal courts, but generally these types of actions are filed in federal court. The reason why is that plaintiffs don't want to sue in state court because they're suing the state government or the local or municipal governments, and they may not get a fair shake in the case. So they go to federal court, which is somewhat removed and more neutral and detached. Now, under the Monell decision, liability will be found where a violation of federal protected right was caused by a policy, custom, practice, or rule, which includes failure to have a policy, failure to train on the policy, and failure to enforce the policy through supervision. So Monell extended the liability to agencies for failure to train and failure to act. More often than not, most of these 1983 actions, they do name the individual officer or deputy, but then they go after the agency because the agency has more money than the individual officer. And they base it on failure to train or failure to supervise theories. Of course, the plaintiff must prove their case by preponderance of the evidence, but these are very, very important cases for law enforcement supervisors and managers to know about, because the agency is exposed here tremendously to large judgments, and usually bad press occurs against the agency if the allegations are proven. Examples of an agency's failure to train, which would result in 1983 actions against them should a constitutional right or federal right be violated by the rogue officer per se, is the use of deadly force. If you do not train your officers in the proper use of stun guns or a vascular restrictive maneuver to render a suspect temporarily unconscious, if you will. If you don't properly train your officers in these valid maneuvers, often valid maneuvers, then you have liability. So, law enforcement agencies must be on guard and make sure that they train and constantly update their procedures so that they avoid the 1983 actions. And just the rogue officer is responsible for their actions. 1983 action liability also stems from theories of failure to supervise. Famous case, which we'll take a minute and discuss, is the Shaw versus Stroud case. Very famous from the Supreme Court. The principle is firmly entrenched that supervisory officials may be held liable in certain circumstances for constitutional injuries inflicted by their subordinates. Recognizing that supervisory liability can extend to the highest level of state governments, we have noted that liability is ultimately determined by pinpointing the persons in the decision-making chain whose deliberate indifference, there's that phrase again, permitted the constitutional abuses to go unchecked. This is a famous case that basically allowed for liability to attach to supervisors, even if the supervisors didn't physically participate or even know of the rogue officer's activities that night on the shift. They may be liable for failure to supervise. That is kind of scary, especially for most of the listeners of this lecture, because you're law enforcement supervisors. You're thinking to yourself, oh my, I'm exposed to my subordinates, liabilities and actions and inactions. And that's true. If a failure to supervise theory is put forth in a 1983 action and proven by a plaintiff by preponderance of the evidence, it's one of the most cited cases on liability and imposed for failure to supervise. Let's talk about this case because it's so important. A suspect was driving, allegedly for DUI, and he was a 47-year-old black male. He was being followed by the police, and he pulled into his driveway, and the police had activated their emergency equipment and lights and sirens, but he refused to stop. He did pull into his own driveway ultimately and fled on foot. He was caught, and a fight ensued. Officer Morris shot and killed the suspect. Now, that doesn't, seem out of the ordinary per se, but when you dig into the history and facts, you'll see what the problem becomes and arises. Sergeant Stroud, who was a defendant in this federal litigation, was Officer Morris's supervisor for over 5 years, until the 15 months prior to the shooting. So, Stroud was Officer Morris's supervisor up until 15 months prior to the shooting. As Morris's supervisor, Stroud received reports about Morris's excessive force throughout the years. There were allegations that Morris used excessive force, and Stroud was on notice of these. The court cited several instances where allegations of excessive force came from Stroud's attention, and he failed to take any action. Morris had a disproportionately high number of assault charges against arrestees. 6 of the 9 assaults on legal charges were by Morris in 1 year during Stroud's tenure. So Morris seems to be arresting and filing assault charges against arrestees of minorities. There were 46 arresting charges, 20 brought by Morris. In a 6-year period, 13 arrestees by Morris claimed he used excessive force. So we're kind of getting into the facts and the scenario that shows that Morris is a bad apple. And it seems like Stroud should have known about it and did know about it. Sergeant Smith became Morris's supervisor before the shooting. He knew nothing about Morris's history. Remember, Morris was transferred about 15 months prior to the incident to Sergeant Smith's division. A judge brought Morris's activities to the attention of another sergeant, who then told Sergeant Smith. So evidently, Morris really had a reputation locally. Even the judges were complaining and brought to the attention of different sergeants in the force about Morris's conduct. The judge saw a pattern of force against black suspects and persons in lower socioeconomic classes. Sergeant Smith took it upon himself and decided to closely monitor Morris before this incident all occurred. Sergeant Smith rode with Morris at least twice in his squad car. Complaints continued. Sergeant Smith sent a line sergeant to observe a trial involving force complaints against Morris. However, no evidence of misconduct was brought forward in these prior incidents in a prior case before this event. Morris received counseling for rudeness to a fire chief at an accident scene. These are all facts building up to Morris's propensity to violate people's rights, and especially minorities, and target minorities, and use excessive force. 3 weeks before the shooting. There was a fight and a shooting, remember, stemming from the DUI pullover. Morris had to take a DUI suspect to the hospital for a fractured skull, which occurred during the suspect's arrest. The allegation was that Morris hit the suspect on the head with his gun. Although Sergeant Smith responded to the hospital, there was no evidence that Sergeant Smith knew of the allegation. Shroud Court identified 3 essential elements necessary to establish supervisory liability under 1983 actions. So this is the first time the Supreme Court articulates the 3 elements. Number 1, the supervisor had actual or constructive knowledge, knew or should have known, that subordinate was engaged in conduct that posed a pervasive and unreasonable risk of a constitutional injury to citizens like the plaintiff in Shroud's case. The supervisor's response was so inadequate as to show deliberate indifference. There's that key phrase again, deliberate indifference to or tacit authorization of alleged offensive practices. And there was an affirmative causal link between the supervisor's inaction and the constitutional injury that the plaintiff suffered. So remember, this is a wrongful death action, constitutional violation being alleged against the officer himself, Morris, and Shroud, the supervisor, and other sergeants who failed to act, allegedly. So the issue is, not so much is Morris liable, because evidently it was a wrongful death action and he abused and misused his force and killed someone unnecessarily, a suspect unnecessarily. But the issue is, now is the supervisor liable? Is Shroud, the former supervisor, liable, who knew about this for 5 years? Or is Smith, Sergeant Smith, the new supervisor, who only had Morris under his command for 15 months, is he liable? And the courts looked at both Shroud's actions and inactions and Smith's actions and inactions, and ultimately held that Sergeant Shroud had knowledge of Morris's conduct and was deliberately indifferent to it. So Shroud was personally liable for the damages, for failure to supervise. Even though 15 months had passed between Shroud's supervision and the shooting, the court said Bowen's death, who was obviously the DUI driver, the driver, the victim, the decedent, was natural and foreseeable consequence of Shroud's failure to investigate or even address pervasive violent propensities of one of his officers. Since Sergeant Shroud knew of Morris's frequent use of excessive force, it follows that he knew that Morris's unchecked service on the force posed a constant and dangerous threat to the welfare of arrestees. What about Sergeant Smith's liability here? The court held that while maybe not the most effective, Sergeant Smith's actions were sufficient to overcome deliberate indifference or tacit authorization on his part. Sergeant Smith, as you recall, authorized 2 ride-alongs and his assignment of a line sergeant to observe the court, a prior court case alleging Morris's improper conduct and excessive force. So, the court ultimately granted summary judgment to Smith. Sergeant Smith was not found liable for failure to supervise under a 1983 action. So what comes out? The takeaway of Shaw versus Shroud, the principle is firmly entrenched that supervisory officials may be held liable in certain circumstances for the constitutional injuries inflicted by their subordinates. Now, why are 1983 actions so concerning to legal staff of law enforcement agencies and to law enforcement agency supervisors and public safety directors and managers and city managers and commissioners? Because unlike state claims, federal claims have no cap on damages. If you recall, we had a conversation about sovereign immunity. And generally, a law enforcement agency can only lose so much money. if the case can even proceed at all, they can only lose so much money. In Florida, it's about $200,000 or $300,000 per claim. Therefore, they don't go bankrupt. But that is all state law. That's state sovereign immunity statutes. Under a 1983 action, that pierces sovereign immunity limits. Those statutes fall by the wayside. Federal claims, remember, under the U.S. Constitution, if there's a conflict between federal law and state law, the federal law controls. And federal law allows no cap on damages. So an agency can be sued for millions and millions of dollars if it's a wrongful death action or an egregious conduct by one of their officers. And deliberate indifference is shown by preponderance of the evidence. The prevailing party's attorney's fees can recover their attorney's fees and costs. The prevailing party's attorney can recover these costs, which can be tremendously expensive, from the agency itself. So an agency is really, really at risk of not only financial damages, but the public relations damages of these particular cases have tremendous repercussions. So 1983 actions, very, very serious. And you get the attention of your in-house legal staff when an agency is sued for 1983 actions. Now, defendants are either sued in their individual capacity or in their official capacity. Individually, that means they're going after the individual officer or the individual supervisor's personal assets. The money, if they prevail, i.e. the plaintiff prevails, is money out of the pockets of the supervisor. Qualified immunity may exist. Remember what qualified immunity is, and that may get the case dismissed, may or may not. But qualified immunity is a defense used by the officer or deputy. And if their conduct was reasonable and it's a discretionary act and they're being sued upon that, the courts generally preclude lawsuits against the individual officers. They dismiss them. In other words, no Monday morning quarterbacking, no second guessing of officers' conduct. If it was discretionary in nature under the circumstances, it was reasonable. Or if there was an imminent peril and they acted quickly and legally in what they thought was the best approach to the situation, then qualified immunity may protect the officer. But if not, if a deliberate indifference standard is proven against the individual officer, they're liable for damages and punitive damages. We kind of talked about punitive damages. I'm not sure if we did or not, but we will talk about them now. Punitive damages are those types of monetary awards that are above and beyond your regular damages. When you sue somebody for damages, or in a lawsuit you're suing them for money, you eventually, if you prevail, you get compensatory damages. Your regular damages. Pain and suffering, lost work, lost money, enough monetary award of funds to put you in a place prior to the breach or prior to the tort. That's called compensatory damages, your normal damages. What we're talking about here is punitive damages. Punitive damages are meant to punish the other party. They're in excess of those other types of damages. They could be $1 or they could be $10 million. They could be $32 million. They could be huge. And they're awarded by judges and juries to punish the actor. So, under 1983 actions, the money could come out of the individual officer's pocket, and it could include compensatory damages or punitive damages if the qualified immunity defense does not work. Other defendants in the 1983 action are sued in their official capacity. What that means is it's really a lawsuit against the agency. Often is the case. Usually what happens is that the individual officer or deputy is sued personally, and then the supervisors and the agency head, the sheriff or the police chief, is sued in their official capacity. In the official capacity, there is no qualified immunity available, But the lawsuit is really against the agency, and no punitive damages are available, just compensatory damages. These are big cases. These are very problematic to law enforcement agencies. Now, there are other defenses besides sovereign immunity. It's the good faith doctrine. Good faith defense. It's used in 1983 actions, and it is available under Florida for tort law violations as well. And it means that the officer acted with honest intentions under the law, and in absence of fraud, deceit, collusion, or gross negligence. So in other words, they may have done wrong, but they didn't mean to do it on purpose. That's a valid good faith defense afforded to officers. Good faith defenses are most likely to be upheld if the officer acted in accordance with the agency's rules and regulations, if the officer acted pursuant to a statute that he or she believed, to be reasonably valid, but is later declared unconstitutional. If the officer acted in accordance with orders from a supervisor that are believed to be reasonably valid. If the officer acted in accordance with advice from legal counsel, so long as advice is believed to be reasonably valid. These are valid defenses to 1983 actions to insulate an individual officer from personal liability. If they can articulate and prove some of these defenses or one of these defenses, then they escape personal liability because they acted in good faith. But it's up to the officer to prove these. Often laws change, and if the officer believed that the law was valid at the time he did it, or conducted her search, and later the law changes to make the search illegal, but she didn't know about it because it's such a recent change, that's a valid good faith defense. Didn't mean to violate the law. Other defenses is the existence of probable cause. This is a very big defense. It's available only in cases of false arrest, false imprisonment, and illegal searches and seizures, either under tort law or Section 1983. What it basically means is there's a reasonable good faith belief in the legality of the action taken. Expectation is lower than the Fourth Amendment definition. Often people think, oh, well, I was charged with a crime, I was arrested, but you know what? The state dropped the charges, or I was found not guilty, and therefore I'm going to sue under a 1983 action. Well, that's not really the way the law is written to allow such cases. So long as there's probable cause, then the officer acted in good faith. It is apparent from the existence of probable cause that an arrest should have been made, even if there was no subsequent conviction or the charges were dropped. As long as there was probable cause, that shows that the officer, at the time the arrest was made, was acting in good faith. And therefore, that's a valid defense to 1983 actions. Note that when facts and circumstances within the officer's knowledge and of which they have reasonably trustworthy information are sufficient in themselves to warrant a person of reasonable caution in the belief that an offense has been or is being committed. That's the definition of probable cause. A valid defense to 1983 actions. Now, there are other federal laws under Title 42 and Title 18 of the USC, the United States Code, that law enforcement agencies are susceptible to liability under. And here's a whole list of them. We can't go through them all. We've discussed the main one, the 1983 action. That's a civil action for deprivation of civil rights. That's the primary one. But if there's a conspiracy to interfere with civil rights by the agency personnel, that's a separate law. Equal rights under the law, 42 U.S.C. 1981 is another federal type of claim. There is criminal liability if the action is so egregious under Title 18 U.S.C. Section 242, the law enforcement officer can be actually sanctioned and put into jail, face jail time. So there are other federal laws here, but the big one is the 42 U.S.C. 1983 or 1983 action. Those are really of concern to law enforcement agencies. Now, another issue here in federal liability area for law enforcement is, of course, the use of profiling, illegal profiling. And this entails a discussion on Terry stops. Terry stops have been around for many, many years, since 1968, when they were validated by the U.S. Supreme Court in a famous case, Terry versus Ohio. Profiling of suspects is perfectly legal. However, if you start to engage in illegal profiling, that's a problem for a law enforcement agency. You get into federal claims of discrimination and can be sued. But let's first talk about Terry stops. Terry stop is a stop of a person by law enforcement officers based on reasonable suspicion. Notice it's not the probable cause standard, which is a higher standard. Just reasonable suspicion that a person may have been engaged in criminal activity, whereas an arrest requires probable cause that a suspect committed a criminal offense. The facts in the Terry case, it's an old case, but a very interesting case. In October 31st, Halloween, 1963, a detective, while on beat in downtown Cleveland, Detective Martin McFadden, he was about 62 years old, and he saw two men standing on a street corner, acting in a way in which was suspicious. The detective was well known on the Cleveland police force for his skill in apprehending pickpockets, and he observed the two who proceeded alternatively back and forth along an identical route, walking, pausing, and staring into the same storefront window at night. In other words, they were casing the joint. They would both walk back and forth in front of this storefront glass window and peer in and then go discuss it with each other on a corner. The two men repeated this ritual alternatively 5 or 6 times apiece. Roughly about a dozen trips back and forth. And the detective looked at this from a distance. He observed this. Then a third man came along. And then he left. So he joined the group and then he left, this third man, after a brief conversation. So the detective, suspecting the two men were casing a job for a stick-up or breaking into the premises, the detective followed them, the two men, and saw them rejoin the third man a couple blocks away in front of the store, in front of another store. Now this detective was in plain clothes, and he approached all three, and he identified himself as a police officer and asked for their names. The men mumbled something, was unclear what they mumbled, whereupon the detective spun Terry. Mr. Terry was one of the suspects, one of the three, around, patted him down on the outside of his clothing, and felt a pistol in his overcoat pocket. He reached inside the overcoat, but was unable to remove the gun. The officer ordered the three into the store. He removed Terry's overcoat, took out a revolver, and ordered the three to face the wall with their hands raised. He patted down the outer clothing of Clinton and Katz, the other two suspects, and he seized a revolver from Clinton's outside overcoat pocket. He felt the guns. They eventually were revealed. The three were taken into the police station and subsequently charged with carrying concealed weapons. Ultimately, the case went up to the Supreme Court. The defendants claimed that, hey, their rights were violated. They were searched without a warrant. And the Supreme Court said under these facts, they said no, they legitimized a stop and frisk type procedure called a Terry stop. If there's reasonable suspicion that the person may have or is engaging or about to engage in criminal activity, an officer is allowed to do a stop and frisk under the Terry stop. Keep in mind that this was one officer, one plainclothes detective against 3 suspects. And so the outcome is not surprising that the finding of this evidence via a Terry stop pat down was admissible. The courts felt like this was a way to properly and safely allow officers to protect themselves, to do an initial pat down. Even though there was not enough probable cause yet for an arrest in that scenario, there was reasonable suspicion for the confrontation of the 3 suspects and a quick stop and frisk of them to make sure they're not armed. Now, Terry stops are limited to an officer searching for weapons only. It's meant for officer safety. Can't be a full search, and if something that the officer feels is not a weapon, that cannot be further investigated without consent or a warrant. Or until probable cause occurs and arrest occurs, then you can search the suspect completely. So Terry stops tie into illegal profiling accusations. In New York, there was a movement in 2014 and 15 where the New York Police Department was accused of misusing Terry stops and using them predominantly on minorities. And there was a reining in of Terry stops. But in reality, the Supreme Court has already spoken. In fact, the Supreme Court is the one who created this ability, this police tool called Terry stops or stop and frisk. But there is liability if stop and frisk is being used to target minorities. Then a federal or state or local law enforcement agency can be sued under a 1983 action for discrimination also. So how do you limit liability? We've talked about a lot of liability, but how do you limit it? Well, the key thing here under 1983 actions is to do something. Don't sit on your hands. You have a duty to know and a duty to act. The worst thing you can do is not act, because that would show deliberate indifference. Supervisors can be personally liable if they show deliberate indifference in the supervising or training of their subordinates. What a supervisor knows is attributable to the agency. You cannot ignore what you see, hear, and know. It will not go away. Document, document, document. Address the issues as they come up. These are some other important tips. Take suitable action. Have internal affairs follow up. Have them investigate if it's so egregious conduct. If you do not know what to do, then ask. This counts as doing something. Follow procedure and manuals and take action. Train yourself and subordinates. Leverage and share knowledge. Identify issues with your eyes and ears and act, even if it is to redirect the issue. Document. No legalese. Words matter. Review. Follow up to avoid reoccurrence. When in doubt, seek assistance. These are all tips on how to manage that liability under 1983 actions to prevent an instance of a 1983 action being filed, because, boy, these are big and important cases. They can really blindside an agency and expose it to tremendous liability. Well, that concludes our conversation about federal liability stemming from federal laws, and especially the 1983 actions.